Every time a listing agent allows a seller to sell a home in California and pay buyer agent commission, that listing agent has breached their fiduciary duty to the seller. And in fact, if you think through what I'm about to explain in this video, I think you're going to say that a listing agent is really not licensed to sell homes properly in California. They have to have an attorney on the team. And that's because box G3 is almost always being checked by buyers. They're asking for 2.5 or 3% buyer agent commission. That's a material aspect of the contract. It's a very substantial portion of your client's equity. It's probably about the delta between the listing price and where the negotiations will be for the price of the home. So just on a financial basis, it's very material. And secondly, because of what the DOJ's explained to the California Association of Realtors, because they forced the California Association of Realtors to remove all forms related to buyer agent compensation from the listing agent's database, so CAR's well aware of this problem, I think we can conclude that buyer agent compensation may not be offered or agreed to unless there's an attorney on the team. And now I'm going to show you the forms and prove what I just said. I'm going to try to do it quickly. Always, there's going to be more at listingattorney.com. If you'd like to work with me or even find out more about this process, I will have a longer webinar or video series available for everyone there. Now, let's just start with the basic point. And the basic point is the transaction starts. The buyer agent is being forced by the trade association rule to make sure the buyer agrees to their compensation level before they show the property. California law is a bit different. It's before they, as soon as practicable, but no later than when the purchase contract is created. The DRE says the trade association rule is different, and that rule is before they even show the property. That's a significant issue. I wanted to point out. I don't have time to go into what it really does in this video. I'm just going to focus on the point of this video. So this is the broker compensation advisory that buyer agents and seller agents can and probably should give to their clients. And here we see the California Association of Realtors listing agreement forms no longer provide for such offers of cooperating broker compensation, nor does CAR include other forms in its library of forms that might facilitate such offers. I'm going to get to that 1 second, but that's buyer agent compensation and that's why this is an issue. That's the exact point and why it's different now. In the old days, I as a listing agent would go to the client and say, real estate commissions are 6%. For selling your home, I will offer half of those on the MLS. If it was the client of a probate attorney, I might be at 4.5 or 5, depending on what the probate attorney said. But then I'd offer half of that on the MLS. I mean, it didn't have to be half. It could be a quarter. It could be 3/4. But I would talk to them. I would put it in writing and explain what I was going to offer on the MLS. They were my commissions, and sometimes I had to negotiate them to get the deals done. In fact, my most recent sale, which was under these new forms, we had a lot of people at about fair market value. One person came in late. I said, you're going to have to, if you want to get paid, you're going to have to take that. You're going to have to beat where everyone is. Plus, you're going to have to go that much over to get paid. He did. They went over. They were also asking for 2.5%. I negotiated that down. My client had a higher net. I gave in a little bit of my own money. I could quite easily negotiate that because I'm an attorney. A listing agent has no forms. First of all, they're not authorized to do it. They're not legally allowed to do it. It's a third-party contract now. It's not part of the listing commission. It's part of a third-party contract. They can't get on the phone and negotiate it. They're not representing the seller with respect to that third-party contract. There's nothing in the forms where they say, I authorize you to call the buyer and negotiate their third-party contract. They couldn't do it. In fact, I'm pretty sure that's why DOJ told CAR they can't have forms. If buyer agent compensation is involved, quite simply, there must be an attorney. And I can tell you even why. In addition to the listing agent not being licensed to negotiate it, there's also risks. The DOJ pointed out there's a risk of steering. It's very significant. It can be mitigated against. Compromising the fiduciary duty of the buyer's agent. Two aspects to it. One of them is very easily mitigated. The other one, probably. Third, commission fixing. Well, in this framework, and we know that buyer agent compensation has gone up nationally according to Redfin, that again, something that can be mitigated against, but tougher. Depending on how risk averse your seller is versus how much they want to do this deal, you need to customize their response. So I think I just showed, here we showed you that buyer and seller are supposed to separately negotiate their compensation. That says that here. Above it, we saw that car remove forms were related from buyer agent commission from the listing agent. They're not authorized to deal with this at all. They legally can't because they're not attorneys. And we know, let me just prove to you that it's a third-party contract. This is the contract. Every buyer agent has to get their buyer to sign before they show the property. And here it is where they write in 2.5 or 3%. Okay, so it's a contract, third party. The process makes them agree to it before they even show the property. Then they say, don't worry. When the buyer's like, I don't want to pay you $60,000 on a $2 million home, they say, don't worry, we'll get the seller to pay for that. That's this box here. Seller payment to compensate buyer's broker. They can write in 3%, and they're doing that. They're being trained to go for the max. So this is a purchase offer. It's from 6/25. It's the most recent one as of the time I'm preparing this video. Let's say it's a $2 million home. They'll come in here with, say, 1.8, and they'll ask 3%. Now, what's your seller going to do? Well, as an attorney, you might say, well, we should do what makes sense here and split out the negotiations. Negotiations for the payment to buyer agent and negotiations for the price of the home and in terms. So you might say something like this. First of all, and think about, can a listing agent do this? Like, how are they negotiating one of the most important aspects of the contract? Certainly the most important, because the amount of money is substantial, and by agreeing to do it, there's substantial risk. This is the most important part of the contract. And a listing agent doesn't even have a counter. They don't have the language for the counter. They can't advise on the risks of doing the counter. They can't leverage buyer agent compensation to get more money. They can't negotiate to bring up the net for your seller. They're absolutely powerless over this clause. For instance, if I were doing this, I'd say this is sort of like the bare minimum. Box G3 is hereby unchecked. Any request for compensation of buyer's broker must be made in a separate written agreement between buyer and seller and is not a term of this purchase agreement. If your client really wants to get the deal done, you might say, seller agrees to pay buyer agent 2.5% or 3% provided they submit the request on the attached forms. You might say, as long as we get the deal done on these terms by the close. All those things. Just putting buyer agent compensation in play is going to help your client bring up the net. And if your client is interested, it will help you mitigate the risk, because what you write into that attached contract is where the real risk mitigation, the substantial part of the risk mitigation is done. It's partly process, but a lot of it is what you're going to write in there. The more you inform the buyer and the more that you get the buyer to waive certain things, the more your client is protected. I wouldn't necessarily want to go to max protection. It can be done. I don't think many sellers are going to want to do that unless they have multiple offers going on. And if they have multiple offers going on, that's a whole other way to negotiate this. And that's what I did in a recent sale of 1.7. But your listing agent has none of those skills anymore. They've all been removed from them. So this is therefore, let me go back to the slides and close this up. You're the solution. Your process is the solution. We discussed the problem. You know, it sounds like the Morgan Wallen song, right? And I will explain more. I'm not trying to hide the ball. There's so many ways I can work with you, from referring your clients to me. I work with you. I mean, put it this way, and I'll share this more about. I have had referrals from agents, from attorneys who do probate, who work in trust and estates work, from divorce attorneys. And I counsel them, like, what should we tell a client? What are we going to do about this offer? I've counseled them the whole time. So there's just the traditional model we've worked on. Now, I don't think there's a whole lot of attorneys. I don't think there's a whole lot of listing agents who are familiar with the proper process. So at least in the beginning, I think you're going to want to either go to listingattorney.com and watch the series and come up to speed yourself. Like, I know one of the attorneys who refers me clients to me and other people. I know he could do all this himself once I make him aware of it. In fact, I've discussed it with him. He went away. He goes, let's discuss that when I get back. So he might not need to have me do much work for it. He could run with this on his own. Some of you will be at that level. Others will like, John, I want you to work with me on these files. I've got a coaching program for that. Some of you are just like, John, just give me the forms. I'll figure it out. And I'm preparing, a membership area, a process like that with Q&A. I don't know if there's demand for that, but that'll be made available. But the point is, go to listingattorney.com, watch the free series. I discuss the 3 risks. I discuss mitigation and why it's important. And then I make an offer. Right now, the offer would be, give me a call. But if I put all the forms in the membership area, I might say, or sign up for a nominal amount. We'll have a consultation. You'll get the forms. We'll tailor the forms to your practice, and you'll be ready to go. So, listingattorney.com. My name's John McConnin. I'm a real estate attorney and a broker in California. And I didn't just make this stuff up. I have been asked by the California Association of Realtors in the past to train realtors on how to negotiate multiple offers. And I'll tell you, that's a very important part of this process. I also was asked to train in the past on how to do short sales. And so I've been doing this for a long time. I've sold hundreds of homes as a broker all over the state of California. We even used to have an office up in Sacramento back in the short sale days. And I have counseled clients on how to buy directly from the buyer, many files. I have referred out files all over the country, so I've watched what's going on. And in the beginning, I started out defending real estate brokers in court. This was back when the prices first went down back in the 90s, and everyone was suing brokers, especially those who put together second mortgages at the time. So I've been doing real estate for the vast majority of my legal career, and obviously I've been a real estate broker since 2004. So find out more at listingattorney.com. Thank you.